Hello friends, in today's class we will learn about the concept of adoption. And adoption is an act by which a person takes the child from their biological or natural parents to his family and treats him as his own child. In modern Hindu law, the act of adoption is made according to the provisions of the Hindu Adoption and Maintenance Act 1956. In India, the other personal laws such as Muslim law, Christian law doesn't recognize the adoption. In Ramasubhaiya versus Chanchu Ramaiya, adoption was defined as a judicial act creating between two persons certain relations purely civil of paternity and affiliation. Essentials of a valid adoption. According to Section 6 of the Hindu Adoption and Maintenance Act 1956, the requisites of a valid adoption is as follows. The person adopting has the capacity and also the right to take in adoption. The person giving in adoption has the capacity to do so. The person adopted is capable of being taken in adoption and the adoption is made in compliance with other conditions mentioned in the Act. Who can be adopted? According to Section 10 of the Hindu Adoption and Maintenance Act 1956, any child, whether a son or a daughter, can be adopted by the following conditions. The child should be Hindu, the child has not been adopted before, the child should not be married, and the age of the child must be below 15 years. According to Section 11 of the Act, if the son or daughter is adopted, the adoptive father or mother must not have a living son, son's son, son's son, either by a legitimate blood relationship or by adoption, living at the time of the adoption. In the case of the son and in the case of the daughter, there must not have a living daughter or son's daughter, either by legitimate blood relationship or by adoption, living at the time of the adoption. Other essentials. The other essentials of a valid adoptions are: if the adoption is made by a male and the person to be adopted is a female, the adoptive father should be at least 21 years older than the person to be adopted. If the adoption is by the female and the person to be adopted is a male, the adoptive mother should be at least 21 years older than the person to be adopted. And the same child may not be adopted simultaneously by two or more persons. The child to be adopted must be actually given and taken in adoption by the parents or the guardian concerned or under their authority with the intent to transfer the child from the family of its birth. Or, in the case of an abandoned child or a child whose parentage is not known, from the place or family where it has been brought up to the family of its adoption. Adoption by men. Section 7 of the Hindu Adoption and the Maintenance Act 1956 states that any Hindu male who is major is of sound mind is eligible to adopt a child. If he is married, then the free consent of the wife is also needed for adoption. But if the wife has renounced the world or ceased to be Hindu, or a court of a competent jurisdiction declared that she is of unsound mind, that no consent is needed. Also, if the person has more than one living wife at the time of the adoption, then consent of all the wives is necessary for adoption. Thus, adoption without the consent of wife is void. The adoption conducted during wife's pregnancy is valid. Such adoption will not be affected by the subsequent birth of a male or a female child, and the both biological and adopted child will have equal rights over the property. Adoption by female. Section 8 of the Hindu Adoption and Maintenance Act 1956 states that any female Hindu who is major, is of sound mind and who is not married is eligible to adopt a child. If she is married, then the consent of husband is required. Earlier, if the female Hindu was married, she cannot adopt even with the permission of her husband. Later, this was amended. But if the marriage is dissolved, or if her husband is dead or has renounced the world or has ceased to be a Hindu, or a court of competent jurisdiction has declared that he is of unsound mind, then no consent is needed. Subsequent marriage of the adoptive female Hindu cannot invalidate the adoption. The adoption by a divorced wife and widow is also recognized by the Hindu Adoption and Maintenance Act 1956. After divorce, the status of a woman becomes independent. Her position will be like that of an unmarried female. A widow can adopt a child for herself, and after adoption she will become the adoptive mother of the child. A son adopted by a Hindu widow would be deemed to be the son of her late husband also. Who can give in adoption? Section 9 of the Hindu Adoption and Maintenance Act 1956 lists out the persons capable of a valid adoption. Only the father, mother, or the guardian of a child have the capacity to give the child by adoption. A father will have the right to give in adoption with the consent of the mother. But if the mother is dead or completely and finally renounced the world or has ceased to be a Hindu or has been declared by a court of competent jurisdiction that she is of an unsound mind, then no consent is needed. Effects of adoption. According to Section 12 of the Hindu Adoption and Maintenance Act 1956, an adopted child will have all the rights as that of a natural child. If the adopted child has any property with him, it will be continued to remain with him after the adoption also. If certain restrictions is upon the child in marrying someone, such as the degrees of prohibited relationship according to Hindu Marriage Act 1956, that will be continued even after the adoption. Once an adoption is conducted, it will be final and the adopting parents cannot cancel it at any circumstances. Also, the child cannot renounce and cannot go back to the old family. For more such videos, please like and subscribe our channel.